analysis right now. Carrie Severino is president of the Judicial Crisis Network, and Elizabeth Wydra is president of the Constitutional Accountability Center. Ladies, thanks for being here. Elizabeth, first to you. You know, this does track with the leaked draft opinion we had weeks ago. However, it wasn't 5-4, it was 6-3. Anything surprise you in this opinion?
So nothing really surprised me in the majority opinion. It did track closely with that leaked Alito draft. I was surprised, frankly, that Justice Thomas in his concurring opinion was so open in wanting to reconsider precedent that protects the right to choose contraception for married couples and others, marriage equality for LGBTQ couples, and other fundamental rights that, you know, people feared would be at issue if abortion rights fell. But I was surprised he was so open about that. I just simply think that the majority got the Constitution wrong. The Constitution protects a fundamental, irreducible minimum of liberty that was intended to include the right to decide for oneself whether, with whom, and when to form a family. And the right to choose abortion is inherent in that constellation of rights. When the 14th Amendment was passed, it was passed after the Civil War, when the question of what it meant to be free was urgent and pressing as a matter of law. And the sweeping protections for equal protection of the law and liberty contained in the 14th Amendment protect rights, including bodily autonomy and the decision of whether, when, and with whom to form a family.
Carrie, I want to get your overall opinion, but I want to specifically address what Elizabeth mentioned there about Justice Thomas. You know, Justice Alito, in the majority opinion, writes, "We have stated unequivocally that nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion." Justice Kavanaugh also writing, "I emphasize the court today states overruling Roe does not mean the overruling of those precedents and does not threaten or cast doubt on those precedents," seeming to say, despite what Justice Thomas said, we're not going down that other road.
Well, Justice Thomas himself says we're not going down that other road. As Shannon quoted earlier, he said this case doesn't address those issues. It's no surprise that he thinks we should reconsider them, because the idea of substantive due process is something he's long been concerned about, not because of the policy results of those cases, but just simply because of the legal underpinnings. But, you know, I think Elizabeth is right. What we should be looking at is what the ratifiers of the 14th Amendment thought they were doing here, and clearly, because abortion was illegal throughout the country at that time, they thought that this meant the equal protection of the laws. They wanted to free slaves. Absolutely, all of those things had nothing to do with abortion. The Constitution does not create this right, and I'm so glad and relieved that we have a court that understands its job isn't to try to make decisions on these controversial issues for the entire country. Their job isn't to try to make the call between what's the right and wrong way to address the issue. Their job is to simply say, does the Constitution speak to it? If not, it goes to the elected branches, and Congress and the states are going to have a right to do this in the face of all of the hostility, the threats, the violence, even assassination attempts, that they were willing to stand by what they knew was constitutionally required. This is a huge victory for the rule of law.
Quickly, Elizabeth, Speaker Pelosi said in her news conference today that it's a contradiction in her mind that the Supreme Court said you can't make laws governing the right to bear arms. The states can't. And they're saying, she said, the reverse, the states can overturn a constitutional right for 50 years that she saw in abortion. But the right to bear arms is in the Constitution. The right, these justices found, the right to abortion is not. Is that the difference?
You know, I think, honestly, the question is, what does the Constitution mean? And obviously, there's an interpretation about what the Second Amendment means, which the Second Amendment is not about an individual right. That's not what the text says. That's the interpretation. Similarly, you look to the 14th Amendment and you look at the equal protection of the laws, and what does that mean? And the point about states banning, in some states banning abortion at the time of the 14th Amendment, the 14th Amendment was intended to disrupt unjust and unequal state practices. That was, we were coming out of a civil war when half the states were slave and half the states were free. The 14th Amendment was intended to move forward along the arc of progress, and that's what we've done when we applied the 14th Amendment in the case of interracial marriage, in the case of marriage equality, in the case of other rights of hearth and home that have protected individuals' rights to make these decisions for themselves. And Americans know that one cannot be a free and equal citizen in society if they can't make those decisions for themselves. And that's why the majority of Americans support abortion being legal.
Well, now it's up to those Americans in those states to make those decisions. Carrie, Elizabeth, thank you very much. Let's